Good afternoon. I'm Jim Townsend, and I'm the director of the Carl Levin Center for Oversight and Democracy here at Wayne State University Law School. It is my pleasure to welcome you to today's presentation by the winner of the third annual Award for Excellence in Oversight Research, Professor Dave Rapallo of Georgetown University Law Center. Now, before introducing the moderator of today's presentation by our winner, I want to say a word about the Award for Excellence in Oversight Research. The Levin Center established this award in 2020 to recognize important contributions to the emerging field of oversight research. At the Levin Center, we believe that the first job of a lawmaker in Congress or the state capitol is to be the eyes and voice of their constituents. In other words, to conduct oversight, to get to the heart of important public questions and share those findings in good faith with the American people. As our founder and namesake, the late Senator Carl Levin, said, you can't have good government without good oversight. And these days, more and more, we are convinced that the same holds true for democracy. So to understand this critically important process, to help us measure the quality of legislative oversight and understand its impact and how it can be improved, we need to attract scholars to this field and recognize those who make important contributions. That is what the Levin Center Award for Excellence in Oversight Research is all about. Each year, a selection committee here at the Levin Center comprised of faculty members from Wayne State University Law School, our political science department, Levin Center staff, and scholars from other institutions review submissions of not yet published scholarly work that addresses significant legislative oversight issues at the national, state, local, or international level. We accept submissions on a rolling basis until November of each year. And if you want additional information about the award, please visit our website. That is levincenter.org, levin-center.org. And I think we can get the URL posted for the section of the website that has that information about the award. In addition to learning about the rules for the award, you can also read the work of prior award winners and watch video of their presentations of their work. So now let me introduce Professor Greg Fox, who will moderate the presentation and Q&A with this year's award winner. Greg Fox is Professor of Law at Wayne State University Law School and Director of the Law School's Program for International Legal Studies. Professor Fox is a widely cited authority on international law and international organizations, and leads a number of academic and professional organizations in the field. He has also been a valuable contributor to the Levin Center. He's helped us, he's advised us and edited several amicus briefs that we've filed in important oversight cases, including Trump v. Mazars, which is the subject of this award-winning paper. So with that, let me congratulate Professor Rapallo, thank Professor Fox, and turn things over to you, Greg. Please take it away.
Great. Thank you, Jim. Thank you very much. And welcome everyone to what I'm sure will be a really exciting and really interesting presentation. It's a real pleasure for me to introduce our speaker, David Rapallo. David has got his BA from UCLA, his JD from UC Hastings, and not one but two LLMs for Georgetown, from Georgetown University Law Center, where he is now an associate professor of law and director of the Federal Legislation Clinic. David began his career in the Legal Affairs Office of the Office of Governor of the state of California, and then moved to Washington, where he held a number of senior positions on House staff positions at House committees. He also worked at the National Security Council in the White House, and most, I think, importantly for our purposes, from 2011 to 2021, he was staff director of the House Committee on Oversight and Reform. During his time on the Hill, he drafted, contributed to, or edited more than 50 congressional reports, including majority, minority, and bipartisan reports for members and committees. And today he is going to talk about his article, House Rules, Congress in the Attorney-Client Privilege, which has appeared in the Washington University Law Review. So it's a real pleasure to introduce David Rapallo, and the floor is yours.
Great, thanks very much, Greg. I definitely want to start by thanking you, Jim, Margot, Elise Bean, the review committee, and the entire Levin Center team. It's really an honor to receive this award, and I'm happy to be here to be able to present my paper today. Before I jump in, I would just like to highlight that the Levin Center is really serving a valuable function here by fostering this space to help people learn about Congress and its precedents. As we all know, in law school, students are taught case law, which is great, but it doesn't account for the entire branch of government that creates the laws and conducts the critical oversight that's needed to make sure they're followed and they're implemented effectively and efficiently. So thank you again to the Levin Center. I also want to thank my colleagues here at Georgetown for all of their support, and to the terrific team at Washington University Law Review for publishing my paper. As was mentioned, I recently left Capitol Hill after more than 20 years. And just for full disclosure, I was the staff director on the House Oversight Committee under Chairman Elijah Cummings when we conducted the investigation that's the subject of this paper and that resulted in the Supreme Court decision in Trump versus Mazars. And since I'm new to academia, I really value this opportunity to talk to academics, practitioners, and others who are interested in sort of mining or excavating these congressional precedents and elevating them so they get the attention that they deserve. So with that, I will try to put up my slides here. And I will go through it. And just to start, when my students here at Georgetown have a project or presentation that they're working on, we encourage them to always have in mind their ultimate goal, which we call a North Star. And we also want them to have their key top line points. So let me give you mine. First, my North Star for this project today is to help academics, courts, and others, including some members of Congress, become familiar with the basic principle that Congress makes its own decisions on non-constitutional common law privileges. And I've got three top line points for today. First, Congress is not required to recognize the common law attorney-client privilege, but it may do so if it chooses. Second, there's no support for this position in separation of powers principles, congressional oversight precedents, or judicial case law. And finally, I offer an alternative interpretation of this line in Mazars, which we'll go through, that's consistent with all of these, separation of powers, congressional precedents, and case law, which is that witnesses don't waive their common law privileges in other fora when they comply with compulsory subpoenas from Congress. Okay, so as a little bit of background on the Mazars case, there were actually three different House committees investigating President Trump's finances and other issues. And the court consolidated these cases and then issued a ruling in 2020, finding that the president was not above the law, he was not exempt from congressional oversight, but because of separation of powers concerns involving the president personally, the president himself, Congress had to meet a more heightened four-part test to obtain those presidential documents. In the Mazars opinion, the Chief Justice has a background section that goes through some of the standard precedents and case law involving congressional oversight. For example, Congress has a constitutional power to investigate and to compel compliance with its demands. Congress's power is broad, but not unlimited. An investigation has to be properly authorized by the full House or Senate, and it has to serve a legitimate legislative purpose. So I won't belabor these points because he cited well-known cases that this audience is probably well familiar with. However, the Chief Justice also added a sentence about privileges that was due. And I'll put up that sentence now so we can all look at it together. So it says, and recipients, and he's talking about recipients of congressional subpoenas, have long been understood to retain common law and constitutional privileges with respect to certain materials, such as attorney-client communications and government communications protected by executive privilege. So in my paper, I use this line as sort of a launching pad to discuss a wide range of issues relating to common law versus constitutional privileges. So just to break down this sentence, he's got this parallel structure. He talks about common law privileges on one hand and constitutional privileges on the other. Then he gives examples of each. Attorney-client privilege is the common law example. Executive privilege is the constitutional example. And just to be clear, this is dicta. The president was not claiming attorney-client privilege in this case. And as far as I know, it was never even briefed to the court. He also says this idea has long been understood, but he doesn't say by whom, by everyone, by Congress, the judiciary. He doesn't say. So what does he cite to support this assertion? Well, he cites two sources following the same parallel structure of his sentence. First, for the attorney-client privilege claim, he cites a report that was issued by the Congressional Research Service in 2003. CRS is Congress's nonpartisan research arm, and this report was written by Lou Fisher, who some of you may know. Second, for the executive privilege claim, he cites Senate Select Committee versus Nixon, which is the famous case finding that the president has a constitutional basis for asserting executive privilege before Congress, but it's not absolute. It can be overcome. So I'm going to come back to that CRS report because it's a big part of this, this interpretation that I have, but let's just keep that in mind as we go along. So my paper tries to answer the following question. Is Congress required to recognize the attorney-client privilege, which is a common law privilege? And to do that, I examined three possible sources of authority for such an assertion: separation of powers principles, congressional oversight precedents, and judicial rulings. And after reviewing these, I come to the conclusion that no, Congress is not required to do so. So here's what my paper finds. First, committees are not required to recognize common law privileges, but they may do so if they choose. And this is really the fundamental point. There's a distinction between common law privileges on one hand and constitutional privileges on the other. Congress is required to honor applicable constitutional privileges, but if it's not a constitutional privilege, then Congress can decide for itself whether, when, and to what extent it will apply that privilege. The next point is that the attorney-client privilege is in fact a common law privilege. It's one of the oldest. Judges apply it in their courtrooms. They change the scope of this privilege over time, and they'll continue to shape it as a common law privilege. But there's no precedent, at least that I could find, indicating that the attorney-client privilege has a constitutional basis. In fact, the opposite is true. The privilege is uniformly referred to as a common law privilege by the Supreme Court and lower courts, and they explain that it does serve valuable public policy interests, but they don't claim that there's a constitutional basis for it. And even in the Mazars opinion, the Chief Justice is referring to it as a common law privilege. So in practice, on Capitol Hill, committees like mine regularly recognize and respect the policy interests that underlie the privilege, and they routinely use their discretion to allow witnesses to assert their privilege. Committees may decide not to press the issue, or they may explore other ways to gather information they need. So I don't want to leave the impression that Congress doesn't recognize the value of the privilege, but committees safeguard their authority to overcome it if they determine that doing so is necessary to fulfill their many other responsibilities under the Constitution. It doesn't happen frequently, but it does happen. And I just want to point out one important point, which is this has been the congressional position for generations across both political parties. So this isn't a new position that I'm describing here. It's what Congress has been doing, both Democrats and Republicans, even if some people may not be aware of that. So with that, let's go into a little bit more detail on each of the three possible sources of this authority. First is separation of powers principles. So in addition to having the constitutional authority to investigate and the accompanying power to compel production of documents and testimony, each House of Congress also has its own independent authority to establish its own rules. And this power is explicit in the Constitution. So using this authority, both the House and Senate have delegated these constitutionally based investigative powers to their committees. And the chairs of these committees make rulings on common law privileges. In the House and Senate rules, committees are assigned their jurisdictions, They're given certain powers to conduct investigations, like holding hearings, demanding documents, issuing subpoenas, and holding witnesses in contempt if they refuse to comply. But here's the key point. So because Congress's authorities in this area derive from the Constitution, any limitation on them also has to derive from the Constitution. So what does that mean? It means that while Congress must honor constitutionally based privileges, like the Fifth Amendment privilege against self-incrimination, or the constitutional protection for executive privilege, Congress gets to decide for itself on common law privileges like the attorney-client privilege. So in terms of Congress deciding for itself, I also discuss in my paper how previous efforts by some to have the House or Senate adopt a new rule that requires committees to recognize the attorney-client privilege have been rejected repeatedly. So just to be clear, either the House or Senate tomorrow could adopt a rule requiring their committees to recognize the attorney-client privilege as a matter of right in all cases. Or either House could adopt a rule that has certain exceptions, such as the crime fraud exception. But the House and Senate have chosen to continue the existing process, which is for committees to make these determinations on a case-by-case basis in light of the facts at hand and the significance of the information they're seeking for the investigation. And that's their prerogative under the Constitution. The point is, because it's not a constitutional privilege, the decision is for Congress to make, not the courts. And if it were otherwise, that would mean that any common law privilege that's available in court could be applied to Congress without any basis in the Constitution. And under separation of powers principles, that would be impermissible, because it would basically allow the judiciary to aggrandize itself at the expense of the legislature with no legitimate source of authority to do so. Next, I'll turn to congressional oversight precedents. So before I get into these, in the Mazars opinion, the Chief Justice didn't make any reference at all to Congress's longstanding position on the attorney-client privilege. Why not? Of course, we don't know. Maybe he just wasn't aware of it. But I have personally seen, when I worked on the Hill, how this is sometimes surprising for people who don't typically practice before Congress. It's also surprising when lawyers can't object at congressional hearings, or can't demand their own discovery, or exclude hearsay, or cross-examine witnesses like they would in court. But lawyers who do frequently appear before Congress are familiar with these differences. So in the next section of my paper, I go through some of the congressional sources that have conveyed Congress's position on this specific issue. Put these up here. So I identify all kinds of documents in which Congress has explicitly expressed its position on the attorney-client privilege, ruled on individual claims, and held witnesses in contempt for not complying. Now, the footnotes in this section of my paper are a little dense, but I wanted to show how many different types of sources could have been identified if someone was looking for them. So just to briefly go down this list, I included examples of hearing transcripts in which chairs or other members explain this position on the record. I identified letters sent to witnesses clearly stating a committee's position, usually along with a demand for documents that witnesses are withholding. Congress has expressed this position in reports that are compiled by staff, as well as reports voted on by members, committee reports. I identify committee rules that include this position, and I point out where this position is included in instructions that committees send to witnesses on how to comply with subpoenas. I go through contempt citations, contempt reports, and I cite legal opinions that are issued by various congressional offices documenting this position. And finally, I quote from speeches that were given on the floor by members of Congress and included in the congressional record. So my goal in doing all this is to show whoever might want to see it that there are plenty of documented, citable sources that explain Congress's position, that it determines when to recognize the common law attorney-client privilege. Now, there's one thing these examples have in common. They're all congressional documents, right? They're not court cases, which I'll cover next. But this may help explain, at least in part, why some judges could be less familiar with this issue. Nevertheless, these sources are concrete, valid expressions of Congress's authority under the Constitution. Yet the Chief Justice didn't cite any of these. So at this point, I'd like to return to the one source the Chief Justice did cite. That's the CRS report that was written by Louis Fisher in 2003. So of course, I pulled that report, And I read it, but it doesn't say that Congress is required to recognize the attorney-client privilege. It says Congress must recognize constitutional privileges. So then I called Lou and I said, am I missing something? He said, no, that's not what the report says. It's not what it stands for. And as you can see, I put Lou in my acknowledgments for the paper because he very graciously agreed to read it and offer comments. So it's really hard to understand why the Chief Justice is citing CRS here. And of course, since I come from Congress, I was personally sort of perplexed on CRS's behalf. And as I said, CRS is Congress's research arm. So this is how I read that line in the Mazars opinion, that the Chief Justice appeared to be citing Congress's own research arm for the proposition that Congress doesn't have authority that it's claimed for generations. So my next research project was to see if there were any other CRS reports that might have said what the Chief Justice asserted. However, I found exactly the opposite. CRS has issued reports year after year after year, highlighting the congressional position and giving examples. I'm not going to read all these quotes, they're all in the paper, but the point is, if anyone had been looking for CRS reports that discuss the attorney-client privilege before Congress, these are some of the reports that would have turned up. And this list doesn't even include their most authoritative source, the Congressional Oversight Manual. That manual is reissued every few years, and it also sets forth the congressional position. The most recent one says, quote, investigative committees are not bound by court-created common law privileges. Here, I just want to take a slight detour and highlight something that's in my paper. After the Mazars decision was issued, there was an official from CRS who was called to testify before Congress at a hearing, and he was asked if the Chief Justice's sentence in Mazars comports with CRS's 2003 report. And he testified that it does not. And another reason I bring up that hearing is because the Levin Center's own Elise Bean was also testifying that day. And she also explained the same thing. She said, for my entire 30 years, my understanding is that Congress is not bound by common law privileges. And Elise was in great company that day because sitting right next to her was a former House counsel who testified to exactly the same thing. So if one of the core challenges here is that the judicial branch is just not familiar with Congress's position or all these CRS reports or all the other sources that I cite in the paper, I thought one contribution I could offer was to memorialize some case studies from my time on the Oversight Committee. My paper goes through 4, and I'm just going to discuss some broad themes about them. First, these case studies involve 4 different chairmen of the committee over 2 decades. This is not a case in which one chair is acting in a way that's fundamentally different than the others. They all took the same position. Second, they're from both political parties, both Republican and Democratic lawmakers, making requests for attorney-client information and obtaining it when necessary, citing their constitutional authority to do so. And third, all of these cases illustrate how important it can be for Congress to obtain this information when they're trying to fulfill a valid constitutional legislative branch purpose. So in terms of these cases, both the Blackwater case and the TSA investigation, Congress passed legislation after the investigations to address the abuses that were uncovered. In the financial crisis inquiry, Bank of America returned hundreds of millions of dollars to the Treasury. And in the census investigation, our committee helped expose the executive branch's secret, illegitimate purpose in trying to add a citizenship question to the census, which the Oversight Committee had direct jurisdiction over. Okay, next, I will turn to judicial precedents. Here I found no judicial precedents indicating or even suggesting that the attorney-client privilege is based on the Constitution. Instead, it's always been described as a common law privilege. Of course, there's the famous Upjohn case in which the Supreme Court discussed the privilege and its common law origins. And as I mentioned, Chief Justice Roberts continued to refer to it as a common law privilege in the Mazars opinion. I also found no cases indicating that Congress is required to recognize this common law privilege in its own proceedings. Instead, the cases show that federal courts have refused to examine the wisdom or propriety of House or Senate rules unless there's a constitutional concern. So for example, in one older case involving how the House determined the existence of a quorum, the Supreme Court made clear that the appropriate role of federal courts is limited to determining the constitutional validity of a congressional rule, not whether it serves broader public policy interests. Those purposes are reserved for Congress to determine. And as the court said in that case, Congress's explicit rulemaking power in the Constitution is, quote, absolute and beyond the challenge of any other tribunal, except in cases of competing constitutional limitations. Finally, federal courts have dismissed suits against Congress using the speech or debate clause when those suits are brought by witnesses challenging Congress's authority to obtain attorney-client information. And on this point, I'll just like two cases and describe them briefly where the court did this, First is a case from 1977 in which the Subcommittee on Oversight and Investigations of the House Commerce Committee was investigating international uranium price fixing. And the subcommittee subpoenaed attorney-client information from one company, Westinghouse, and then another company, Gulf Oil, sought an injunction in the DC District Court to prevent Westinghouse from producing it. The district court examined the constitutional issues. It found the subcommittee's investigation was properly authorized by the House and that it served a valid legislative purpose. But after the court did that, it refused to examine whether the common law privilege applies in Congress. Why? Because it's not a constitutional privilege. So in that case, the court held that the speech or debate clause prevented any further review of this non-constitutional matter. In the other example, Senator Sam Nunn, who was the chairman of Senate PSI, subpoenaed attorney-client information relating to efforts by Provident Insurance to avoid paying claims that were required under Medicare. So in that case, the company sought an injunction from the district court in the Eastern District of Kentucky. And the company filed there because that court ruled in previous litigation not involving Congress that the document at issue was covered by the attorney-client privilege. So the company wanted that same ruling applied to Congress. But the district court refused, finding not only that the claim was premature, but even if it were properly brought, an injunction would be improper because federal courts are restricted from ruling on evidentiary privileges in Congress that are not derived from the Constitution. The court even distinguished its previous ruling in the earlier case that didn't involve Congress and said this, quote, that ruling, which is not of constitutional dimensions, is certainly not binding on the Congress of the United States. One other thing which is not on this slide is that after that ruling came down, Chairman Nunn made very clear the distinction between a court ruling on the attorney-client privilege in separate litigation and his own authority to rule on the privilege as chairman of PSI. He said this, the court has made a ruling governing its proceedings, and as chairman of the subcommittee, I will make a ruling governing these proceedings. So just to recap, I find no support in separation of powers principles, congressional oversight precedents, or judicial cases for the proposition that Congress is required to recognize the common law attorney-client privilege. Instead, my paper provides plenty of support for Congress's longstanding position. So let me just back up now and go to that original sentence from the Mazars opinion. One possibility is that this claim about the attorney-client privilege is just wrong. When the opinion first came out, there were a number of people who pointed this out. They also highlighted that it's dicta, and people in this camp basically just said it should be ignored as irrelevant and inaccurate dicta. Another possibility is that Chief Justice meant to declare a new policy, even though it wasn't at issue and it wasn't briefed, basically saying from now on, going forward, federal courts get to tell Congress which common law privileges apply in congressional proceedings. Lawyers here in DC certainly started citing this line when they didn't want to produce information, even as Congress continued to assert its longstanding position. And personally, I think it's unlikely that Chief Justice would have made such an extreme policy change without any more explanation in the opinion. Another possibility is that he meant what he said, that witnesses retain these privileges, but he left unsaid the idea that Congress rules on common law privilege while courts rule on constitutional privileges. In other words, he just left out the part about who decides whether the privilege applies in which forum. And for a great take on this, I urge everybody to check out Michael Stern's piece on the Point of Order blog, which is a terrific resource. He lays this out as a likely scenario, and it also appears to be where CRS is landing as well. So these are some of the possible interpretations of the line. In my paper, I offer another alternative, which is this. Recipients of congressional subpoenas retain their privileges, common law and constitutional, in other fora, separate and apart from the congressional inquiry. In other words, a witness doesn't waive these privileges in a subsequent court action just because they comply with a mandatory subpoena from Congress. And I acknowledge in the paper, the perils of trying to figure out what the Chief Justice was thinking. We don't know. Maybe one day he'll explain it. But in the meantime, I came to this conclusion not only because it honors Congress's constitutional authority in this area, but it gives specific meaning to the CRS source that he cited. And for this, I want to explain. If you look at the specific citation, the Chief Justice points to pages 16 through 18 of the 2003 report, and that discusses the Senate Whitewater investigation. That case involved notes taken by an official from the White House counsel's office during a meeting with President Clinton's private attorneys. Clinton did not invoke executive privilege, but he did invoke attorney-client. The main concern from the White House was that by producing these documents, they could be waiving their privilege in proceedings before, quote, other investigative bodies. In that case, both the chair of the Senate Whitewater Committee and the House Banking Committee made clear that complying with mandatory congressional demands doesn't waive your attorney-client privilege in other fora. In addition, in a separate part of his opinion, Chief Justice Roberts highlighted how the Senate, in fact, obtained the attorney-client information in that case. So if you think about that, the White House wouldn't have had much incentive to negotiate a resolution if it could have claimed as a matter of right that Congress couldn't have the information, right? And there's one more piece to this argument, which is that when the Senate Whitewater Committee issued its contempt report, that report also made clear that the main issue was the waiver issue. And the contempt report also observed that since a congressional subpoena is compulsory, compelled disclosure does not result in a voluntary waiver of the privilege. So on December 25th, 1995, the full Senate voted to confirm the Senate Whitewater Committee's decision to reject the assertion of attorney-client privilege in that case. So then 2 days later, with these clarifications regarding the waiver issue, the White House turned over the information. It was front page news across the country, Whitewater notes being surrendered. And in the text, it might be too small there, but it also has a reference to the waiver issue. So in Mazars, if the Chief Justice meant to say that it's long been understood that witnesses are entitled to the common law attorney-client privilege before Congress as a matter of right, that's just incorrect. Understood by whom? That certainly wasn't Congress's understanding. It doesn't appear to be the judiciary's understanding either, because the Chief Justice didn't cite a single case. Instead, he cited these 3 pages from the CRS report relating to the Whitewater investigation. So just as a takeaway from this case, Congress overruled an assertion by a sitting president. Congress asserted its own power under the Constitution to do so, and Congress actually obtained the information after clarifying that witnesses don't waive the privilege in other fora. That's why I think this alternative interpretation not only comports with separation of powers and honors congressional precedent, but it recognizes the complete lack of any judicial rulings to the contrary, and it aligns with the main concern of the specific investigation that the Chief Justice cited. So those are my remarks. Before we go to questions, we have, I think, a little bonus if the technology cooperates. During this Whitewater investigation, the full Senate voted to reject the president's attorney-client privilege claim. And at the time, Senator Orrin Hatch was the chairman of the Senate Judiciary Committee. So during debate on the Senate floor, he gave a very clear recitation of Congress's authority in this area. And my fantastic research assistant went back and found the original video. It's a little garbled, but we have subtitles. So as you watch this, let me just pull it up here. Just keep in mind that this is the specific investigation that the Chief Justice directed us to.
To defend the prerogatives of the executive branch and the separation of powers. I recognize that the executive branch has a right to confidential communications regarding its core function. After giving this issue careful thought and consideration, however, I have decided that enforcing the proper course of action to take. This issue transcends claims of partisan to the very constitutional authority of Congress to investigate wrongdoing at the highest levels of government. The Senate has a constitutional obligation to conduct oversight hearings. It is a duty to surrender. The President not only claims that the November meeting is cloaked in attorney-client privilege, but that the privilege applies against Congress. No Congress in history, however, has recognized the existence of a Congress that trumps the constitutionally authorized investigatory powers of Congress. While Congress has chosen, as a matter of discretion, clear, legitimate claims of privilege, it has never, to my knowledge, allowed its constitutional authority to investigate wrongdoing in the executive branch to be undermined by universal recognition of the attorney-client privilege. As Senator Sarbanes has noted, we have chosen in our discretion to recognize the privilege with respect to some of the witnesses who have testified before the committee. The attorney-client privilege exists as only a narrow exception to broad rules of disclosure, and the privilege exists only as a statutory creation or by operation of state common law. No statute or Senate or House rule applies the attorney-client privilege to Congress. In fact, both the Senate and the House have explicitly refused to formally include the privilege in their rules. As the clerk of the House stated in a memorandum opinion in 1985, quote, "Attorney-client privilege cannot be claimed as a matter of right before a congressional committee," unquote. The attorney-client privilege is a rule of evidence that generally applies only in court. It does not apply to Congress, which, under Article 1, Section 5 of the Constitution, has the sole authority to, quote, "determine the rules of its proceedings," unquote.
Great. I just think sometimes this issue can be very theoretical and people are not necessarily familiar with it. So to actually see the Senate, the chairman of the Senate Judiciary Committee explaining it on the floor of the Senate really brings some life to it. With that, I would love to take any questions that anybody has.
Wonderful. Thank you so much, David. I can't help but add that I have just finished an article which takes as its premise an egregious misstatement of the law by Chief Justice Roberts in a completely different case and on a completely different area. So maybe there's a common thread there. Well, maybe if it would be okay, maybe I could just start out with a question and then turn it over to our audience, who I'm sure is very interested. And just drawing on your own personal experience, maybe you could tell the audience what people inside Congress thought when the Mazars opinion came down, of the opinion in general, of the line that you've been talking about. How was that received?
Sure. Yeah, I was working on the committee, the Oversight Committee, when it came down. And on the main case, there was a real split on how people felt about it. Like on one hand, you had the, people were happy that the court established that the president was not exempt from oversight. There was no absolute kind of protection. So on that front, people were encouraged. But then they came out with this 4-part test, which nobody had seen before. They just sort of invented it. And the test has not been helpful for lower courts that are trying to figure out how to apply it, because when Mazars went back down, the district court applied it one way, the appellate court applied it another way. So I'm not sure even now that there's clarity on the issue. Also, it was the same day that the court handed down the Vance case, which basically seeking a lot of the very similar information, yet there was no heightened scrutiny. So from our perspective in Congress, a state level prosecutor can get the information with no heightened scrutiny, yet a co-equal branch of government has to meet this new test. So that part was extremely frustrating. On the line about the attorney-client privilege, the oversight world isn't that big, and so there was pretty quickly, text going around and a lot of good blogs that went up immediately, just sort of wondering what happened, like what was he thinking? Some people wondering if he was trying to troll people with the CRS reference. But really just confusion about, do they really know this idea at all that I just sort of went through my whole paper, or are they just not familiar with it? And some people definitely pointed out that 6 of the 7 justices that come from the executive branch, so they may have been sort of predisposed to think of it from an executive branch position.
Great, thank you. Well, I'm now going to start in order with the questions that are in the Q&A box. The way it'll work is I will read out the questions and David will answer. I don't think the audience can see the questions before they are answered, but after they are answered, they will appear and you can have a look at them. So if you have anything now you'd like to put in the Q&A box, please do. If something occurs to you later, please go ahead. So the first question is actually from Mike Stern, whose blog you mentioned. And he says, given that the language at issue was in a section, the language in Mazars, was in a section giving general background on congressional background power, is it possible that the purpose of this sentence was to show that Congress knows that there are legal questions that can be made and must be ruled on with respect to its demands for information? Because Mazars is imposing a series of special requirements on Congress where it seeks presidential personal information, perhaps the purpose of this dicta was to demonstrate that Congress is capable of making the kinds of evaluations that will be required by these requirements. This interpretation would mean that Mazars was not taking any particular position on how Congress should or must resolve claims of common law privilege.
Yeah, so I think that definitely could be an interpretation. Whether it's what the opinion intended is, equally unclear as with my interpretation or probably anybody else. I'm not sure why the cite to CRS would make sense for that interpretation, why that's supported, although CRS reports do lay out in some detail the sort of deliberations that a committee goes through when it's making the decision on whether to honor the privilege or not, and whether to overcome it. And it talks about whether things like whether the privilege would have been recognized in court, or whether there are other alternative ways to obtain the information outside the attorney-client privilege, or whether the witness is being cooperative. These are all things that CRS mentions as pieces that Congress may look at. So sure, yeah, and I would love that interpretation if that's the one that ends up coming out of all this.
Great. Okay, the next question is from Nicole Rementer, and she asks, has Congress attempted to address the waiver issue via statute, federal rules, and expressly say, quote, compliance with congressional subpoenas does not waive discovery privileges in cases before federal courts? If not, in your opinion, why hasn't or isn't Congress interested in such a change in the federal rules? It would seem that addressing that elephant in the room would preclude a lot of federal court resources from being spent, especially today.
Sure. Yes, several times both the House and Senate have considered proposals, legislative proposals, to require committees to observe the privilege. They didn't talk about the waiver issue in particular, but they said basically, should we require our committees to recognize this? And they've always been rejected. I think from the congressional perspective, why would Congress pursue a statutory fix when their view is that the Constitution gives us this power, the rulemaking power, independent for each House? The other part of this is the House could make a decision that's different than the Senate. They could adopt different rules on the attorney-client privilege. That's an alternative I hadn't even discussed. But from the fundamental level, if you have a constitutional authority through the rulemaking power, pursuing a statutory fix that may or may not pass because you also need the consent of the other body and you need the consent of the executive branch wouldn't make sense, I think.
Yeah. I'm not sure if this is what Nicole was getting at, but I suppose another statutory approach would be to amend the federal rules of evidence and say something like the fact that privileged information has been discussed pursuant to a congressional subpoena does not waive the privilege for purposes of litigation in federal court. Obviously, that wouldn't control litigation in state court, but that might be another route.
Yeah. Well, there are some cases on the waiver issue. I looked into this a little bit. I didn't do a totally deep dive, but there are some cases that come out of the House Commerce Committee in the 1990s. A lot of them involved tobacco litigation. And the waiver issue also was sort of not completely settled. So there was a question about how far does a witness have to go, or an attorney rather, before submitting attorney-client privilege for it not to be a waiver. And those cases basically said you have to do more than just receive the subpoena. You have to contest it. You have to make every reasonable objection. You have to try to work with the committee to see if there's an alternative. Basically take all reasonable steps to show that you really tried to work it out, and then be under a real threat of contempt. So there are those cases that are out there, and they happen to dovetail pretty closely with the ethics rules for lawyers also. So the DC Bar issued this opinion in 1999 that basically arose out of a congressional investigation where the lawyers wanted guidance, and where the DC Bar came down was pretty much the same thing. If you get a subpoena, you have to take all reasonable steps with the committee, make your objections. You can't just send a letter, you have to do more. But when the opinion says this, at the point where the committee subpoena is issued, you have a legitimate threat of contempt. You don't actually have to be held in contempt as an attorney. At that point, it becomes compulsory, just like a court order. And attorneys are then permitted to turn it over. So even the DC Bar rules recognize that attorneys can be demanded, can be compelled to produce this information to Congress.
Interesting. Okay, the next question is from Andrew Herman. How does your analysis affect an attorney's decision whether to assert privilege in the face of a contempt threat as contemplated by DC Bar rules? Maybe you've just answered this.
Yeah, I think that would pretty much track. No attorney that I know would produce attorney-client information based on just a letter or a voluntary request, or even a member at a hearing demanding and pounding the table. It has to be an official subpoena, has to be compelled in order to preserve the idea that you haven't waived, and then you have to take all those steps. Now, the other alternative is you can talk to your client, and if the client is willing to waive privilege on a subset of documents, you can negotiate with the committee about that, because from both sides, there's going to be an incentive to try and work something out. From the congressional perspective, we wanted information as soon as we could get it. We wouldn't want to have to wait for potentially litigation over several years, like the Mazars case took however long. So we have an interest in resolving it and getting something. And then the witnesses have a pretty strong incentive to get this taken care of too, especially if they represent corporate interests that may have to report this kind of thing to their boards.
Right. Okay. The next question is from an anonymous attendee. I get your point that the witness doesn't waive attorney-client privilege by complying with the congressional subpoena, but does the witness have any authority to demand that Congress keep the privileged information confidential? If the privileged information is given to Congress and then Congress makes that information public by putting it in a report or a press release or by other means, I think it will be hard for the witness to keep the information out of subsequent court proceedings on the grounds of privilege when the information has been made public by Congress. So do you think Congress has some obligation to keep the privileged information confidential to preserve the witness's argument on waiver? In practice, does this happen?
So I'll start by saying I'm not a trial attorney, and there are probably others who could do this a lot more justice than I can, but I do cite some cases that talk about this. My understanding is that courts would apply the rules that exist in the federal rules of evidence. So whatever those happen to be about what can be admitted and what can't be admitted. The cases that I found on this didn't relate to like a specific statement or a specific document. What they related to more frequently was congressional report. So the House would come out with a report on a certain subject matter, and somebody in the trial would want to admit that report to prove the veracity of a fact or something. And those have been split. The courts have been split about how to rule on those. Some courts say if they have indicia of reliability, if they were bipartisan, these types of things, they'll be more likely to admit the information. But if they're partisan, they don't look very factual, that sort of thing, they're less likely to be admitted. What I would be really interested in is actual testimony or documents and the back and forth there. I mean, of course, there are instances where the public knows something that's public and is not allowed into a case. But I think this is an area that really could be researched a little more heavily.
Yeah, I agree. I think there is something just kind of intuitively strange about a court excluding a fact that everybody knows about. I'm not sure how how up most juries are on congressional testimony, but the juror might know about it. Okay, the next question is from Stasia Cardiel, who says, you say in the presentation that committees respect the policy interests underlying the privilege and routinely use their discretion to recognize it, close quote. Will you please explain what arguments were most persuasive in encouraging you to recognize the attorney-client privilege during your time on the Hill? Thank you.
Yes. So from my perspective, it was most compelling when a witness would come to us in a cooperative manner, trying to come to a conclusion that would help the committee get the information that it needed. And in a lot of cases, especially with corporate or agencies, they know where the information lies in their with their client. They can usually find the information we're looking for not covered by the privilege, if that makes any sense. So in a lot of cases, we're not necessarily looking for advice an attorney gave to a client, but the attorney-client privilege is used so liberally. And if you ever have seen a privilege log that comes up to the Hill, there's very little explanation on what it is. So a client that's willing to come forward, have a privilege log that documents document by document why the privilege is important, and then is willing to talk to us about, okay, we don't need to withhold everything, but could you work something out? Those are the clients that you really have an incentive to work with in order to get the information much sooner.
Great. Okay. The anonymous attendee has, I think, responded to your previous answer and says, I get your point that the witness doesn't waive attorney-client privilege by complying with a congressional subpoena, but does the witness have any authority to demand that Congress keep the privileged information? I'm sorry, maybe this is one we've already asked.
But there was something in there about whether a witness can demand that Congress keep it quiet, which I didn't answer. And the short answer to that is not usually no. Congress really safeguards its right to inform the public. That we view that as part of our core function on the committee, our core legislative branch function. And while a lot of committees will make gentle assurances, like we don't plan on releasing this or we don't envision releasing this, most committees are never going to guarantee that they will always preserve it. So there is a risk anytime you're providing anything to Congress that it could be made public. There are exceptions to that, of course, if somebody's in like a whistleblower situation and is cooperating, but those are more of an exception, I think.
Great. Well, maybe I could, we don't have any more questions in the Q&A box, but I think we do have time if anyone would like to add any. But maybe I could just kind of bring you back to Mazars itself and its practical consequences. Do you know if any witnesses or lawyers representing witnesses have started citing this passage in Mazars as a reason for withholding privileged information? And has Congress, has any committee, issued contempt citations, for what I presumably would view as, an incorrect understanding of the law?
Yeah, there definitely have been attorneys who've cited the privilege, or cited the line in Mazars, rather, to argue that the privilege is mandatory for Congress. There was one example, I think there's a footnote in my paper about this, with my old committee, the Oversight Committee. They were investigating the Washington commanders and the toxic work environment, that sort of thing. And during a deposition, the attorney did that. He cited the line in Mazars, said it's attorney-client privilege, even acknowledged that it was dicta, but still tried to insist that it applied there. The committee, if you read the deposition, you can see this, the committee rejected it. They stood their ground, held to their longstanding position. In that case, it didn't result in contempt. I think they broke the deposition, both sides went back and talked it over, and then the witness withdrew the claim and provided the information the committee was looking for.
Okay, interesting. Another question from the anonymous attendee. How should in-house attorneys balance threats of compulsion, that is, contempt threats with a big reputational costs for a company, against protecting materials we believe are protected by attorney-client privilege? How can we educate our corporate clients about the risks?
Yes, so there are definitely some resources out there that are actually written by corporate interests or those who represent them and do exactly this. I cite a bunch of them in my article, so I would first just look there. And also in my paper, I sort of describe the process that happens when there's this sort of thing. You can really engender some goodwill, I believe, with the committee if you're willing to go through the steps with them to figure out, is there a way to solve it? For example, in addition to the document that you provide that lists out all the privileges for every document, you can do in-camera viewings of samples, and you can say, look, this isn't really going to help you. It's not what you think it is. Let me just show you one sample. We have permission from the client, and you show them. And then the committee, if they're reasonable, say, okay, yeah, we don't actually want that. What we're really looking for is this. But I think just establishing that relationship, and I know it's not always possible with every committee, but for committees who are really interested in obtaining information, they have an incentive to work with you to get the information they're looking for, rather than go to contempt. I mean, the contempt process is just so extended right now. If you think about it, you have to have a subpoena. The committee has to vote to hold you in contempt. The full House or Senate then has to vote to hold you in contempt. Then the U.S. attorney has to actually bring a case. I go through the stats on this. I can't remember exactly how far I went back, but something like 40 years. In the past 40 years, there have been less than 24 actual contempt cases that get all the way through the House. So it's very rare because of how difficult it is to go through. Now, that's not going to give any comfort to somebody who's in the crosshairs of a committee being threatened with contempt, right? So that's why I really think trying to work on what it is that they're actually interested in to see if there is something you can provide outside of the privilege, or even maybe some of the privileged information with your client's consent could really go a long way.
Okay. Yeah, one more question from the anonymous attendee. What is next on the horizon as it relates to this novel legal issue? How do you anticipate this important constitutional issue will ultimately be resolved?
That is a great question. I think if I go back to my North Star for this whole paper and this presentation, it's just to let people know. I really don't think people, especially in the judicial branch, necessarily know about this. So the first part is just letting people know this is a thing, it exists. There's precedent for it. There's plenty of cases that Congress has gone through that do this. And there are even some district court cases that have thrown out efforts to question Congress's authority to do this. So that's my ultimate goal for this, is just education. I have no idea where it's going to end up landing, but it's a fascinating legal question. And it could have implications for other common law privileges, as I mentioned.
Right. Maybe I can just kind of thinking about the dynamic here in which these disputes take place. We've I think kind of been talking about Congress as something of kind of a unified, undifferentiated entity, but of course it isn't that. Each committee makes its own decisions, and those decisions may be consistent over time. They may be consistent across different committees at the same time. They may be consistent between the House on the one hand and the Senate on the other, or they may be completely inconsistent along all those different axes. So one interesting aspect of this dispute between the executive branch and the Congress, in which, as you point out, courts traditionally have not jumped in, is that they're kind of worked out through kind of practical precedent or precedent of practice. But and I don't know if this is the case, but if potentially the practice on the congressional side is fragmented in the way that I've described, how do we come to a coherent understanding of what the congressional position is?
Yeah, and I framed it in terms of, as I did in those top line points, that it's not required to, but it may if it chooses, and it often recognizes the policy interest, but it safeguards its ability to overcome it. But It's a good question, and it's also been raised. There was a commentator in my paper that raised this inconsistency argument. And so for that, I would just point to the states, right? So all 50 states, just like Congress, have an independent authority and ability to establish what their rule is going to be for the attorney-client privilege. And they have different rules. And federal courts have honored those different state interpretations across the board. I pulled one of them was a 2016 case in which the Washington State Supreme Court held that there's no attorney-client privilege for former employees of a company. And the state court explicitly recognized that this conflicts with the Fourth Circuit's position. But the decision was left to the state to decide how it wants to handle its privilege. And then there was another case, it was a Ninth Circuit case. In that case, the California Supreme Court had ruled that for California, the attorney-client privilege doesn't apply to an attorney subpoenaed by a grand jury for business records. And here's what the federal court said about the state court's decision. It says the attorney-client privilege is a matter of state law for determination by the California courts. It's not a matter of constitutional law or under the various amendments. So just like states have the ability to have their own decision honored by the federal courts, Congress should as well, as a separate independent branch of government. And just because some observers may prefer greater consistency among congressional committees doesn't mean there's a constitutional requirement for them to do so.
Great. Thank you. Any more questions from our attendees? Well, in that case, David, thank you very much for an absolutely fascinating talk. If folks have not read the article, I very much commend it to you. It's very well done, and will absolutely, I'm sure, play a role in any litigation that comes up on this issue. And Margot has just put in the chat a link to David's award-winning paper. So thank you so much.
And thank you, Professor Fox and the whole Levin Center. Really appreciate it.
Yeah. Thank you, everyone.